Hello and welcome. I'm Matthew Leopold from LexisNexis, and over the next 30 or 40 minutes or so, I will be guiding our panel and you through the complex and changing world of legal drafting. Now, beyond my boyish good looks, thank you very much, I am in fact a teenage heartthrob. And by what I actually mean is I'm a romantic, which is how I approach drafting and writing. Now, I'm sure you'll be familiar with at least the name, if not the art of Rembrandt, for example. Now, whilst Rembrandt is the cited artist, it was in fact his apprentice or his series of apprentices who actually prepared the canvas. They sketched the outlines, they did the colouring, mixed the colours, and essentially they did all that early graft for Rembrandt. But of course, it was Rembrandt the master who would come in and transform the initial work into the masterpiece by adding light and soul and refinement to match his vision. And it's my view, and the discussion we'll be having today with the panel, is that a similar situation is arriving in the law. Lawyers are facing an evolution of their craft. And the big question is AI becoming that apprentice? AI builds the foundation, but only the lawyer can finish the piece, adding their judgment or the nuance or the intent. And I'm looking forward to discussing with a really interesting panel today to find out what they think. We're joined by Kat Wolfenden, partner, a new equity partner at that, from Weightmans, where she's also the Director of Product and Innovation. She's had a firm hand steering Weightmans' innovation roadmap over the years and has won a number of awards, including being named in the Lawyers Hot 100 list. And she's even written a book about legal innovation, which I understand John Grisham is using as the basis for his next legal thriller. We're also joined by Tim, hopefully by Tim. He's got a couple of technical issues, which might mean he pops up and down like a jack-in-the-box. But Tim is the Director of Knowledge at Pinsent Masons, where he looks after the firm's knowledge management. He's been a very early adopter of AI and other technologies. And I know Tim has worked really hard to centralize his huge database of resources across his firm into the Microsoft environment to make it easier for AI tools to be deployed across their internal know-how. And I've worked with Tim for quite a long time, and I know that today is a topic that is definitely one of Tim's favourite subjects. And we're also joined by Stephen McGeevan, the managing partner at VWV, a big national UK law firm. And since becoming the managing partner, he's really put his money where his mouth is in terms of AI, investing around £250,000 in AI-specific technology. And excitingly, and I'm sure we'll hear more, created an AI innovation program within his firm, getting the trainees to develop AI solutions to improve contract review and report drafting. So let's get started. And ladies first, Kat, has technology changed the role of legal drafting in recent years? And forget about AI for the moment. How has technology changed legal drafting in recent years?
Yeah, sure. So I suppose when we've moved, haven't we, from parchment and quill onto typewriters and then computers. And I suppose lawyers have always passed down, handed around, haven't they, carefully crafted precedents that then moved electronically. They got built into workflows and case management systems, or they got used as document automation, all really to try and get people to be able to capture the vast majority of drafting that people are doing. And I suppose that the aim there was to try to get to a consistent first draft quickly and allowing the work to be done, by maybe more junior colleagues, so kind of pushing work downwards while still giving them that consistent set of rules to be able to draft within.
So, and Tim, what elements of drafting require that human expertise at the moment, do you think?
Well, at the moment, it's all elements should. I mean, I think we've long had precedent documents and clause banks and things like that. And so there's always been an element of, I guess, commoditization of it. But the humans always had to work with them. They are a starting point. They are not the finished product. And of course, once you've finished drafting your first draft contract, you still need to carry on negotiating. So you still need to understand the nuance of it and where this clause can go and adapt. And so I think there is still a need for human expertise to understand the impact of that clause and changes to that clause, even if we get to the position that an AI can draft a whole complete contract. I think we're a way off that at the moment, but it's coming. You can see it. So I think the human is still going to need to be in the loop in all of this. That consistency challenge. AI non-deterministic, so it's going to produce a different clause each time if we just left it to do its own thing. I think that needs that human to bring it back to predictable, consistent wording. So there's, for the foreseeable, I still see a human expertise as necessary, even though the AI, taking your Rembrandt story, the AI can do that apprenticeship bit, make things a bit quicker. It gets you a little further along the line, and then the human takes over.
So, Steve, from a managing partner point of view, right? You look at this in terms of utilization. I'd assume, by the way, in terms of utilization, about how do you use the resources of your firm. Does the technology and that increased efficiency bring extra risk? Is that something that concerns you, or actually is the trade-off quite an important one to maximize the value of your resource?
The risks, do you mean specifically the risk of AI or technology generally?
Technology generally.
I mean, yes, to some extent, and I guess law firms are quite well organized to manage that risk because, there's always been a risk of somebody junior and inexperienced downloading a precedent and then working from that precedent and not really fitting into the circumstances and relying on it. And the safeguards that exist in law firms are supervision from more senior people. And really nothing changes about technology, doesn't really change that, in that there's lots of controls in the process to make sure that what the client ends up seeing or what ends up going out is checked by somebody more senior, and the guardrails come in earlier. So yes, it brings in some risk, but it's a risk that I would say law firms are quite well suited and used to managing.
Quite. And so, Kat, does that increased efficiency risk lead to lower quality documents?
I don't think it leads to lower quality documents kind of as a technology. I think it makes it harder for, like both Tim and Steve have said, for that consistency. And I think it makes it very hard from a kind of a junior fee earner trying to draft to be able to understand either why certain clauses are in, why they're not. And as Tim said, drafting isn't a one-off thing. Stuff comes back to you and you have to interact with it again. And unless you understand, I suppose, the nuts and bolts and why things are in, I think it can make it difficult. We've obviously all recently heard the horror stories, haven't we, of the kind of the fake citations in things. And, that is almost, yes, we'd have, I suppose, you kind of outsourced stuff, didn't you, to counsel and that kind of thing to mitigate some of that risk because they were going to be doing the research. I don't know whether everybody would necessarily have checked every single citation that used to come back in, but that seems to be where the case law is going, and actually we've all got a duty to be doing that. So I think, like Steve said, I don't think it necessarily changes the risk, but I think it gives us a greater volume of things to do, and it's speed, isn't it? So suddenly people can create a lot more documents in a lot shorter amount of time, so whoever's supervising them suddenly has to be able to get through them, and I think that's what it's done, is accelerate the volume of information that people will be looking at over a time period.
Well, let me put that straight to Tim, right? Go on, Tim, because you're the man who's right?
I think one of the risk is that people fail to take ownership, because these the stuff that these tools can come back with can sound very convincing, and the cases that we've seen reported are where people just have said, all right, that's it, job done, and clearly it's not. We still need to check this, and so I think the risk is just failing to own your drafting, and pre-AI tools, of course we owned our drafting because we crafted it. Yeah, and I think the risk now is that people just see this and think, wow, that looks great, and you still need to engage the brain and say, well, is that the right thing for my transaction? And I've long had this concern around clause banks and mining a document management system, that context is important. Was this clause that you're lifting taken from a distressed seller, a sale with transaction with a distressed seller, or have I taken a knock and indemnity regime from an oil and gas transaction? Am I trying to apply that in a retail? That's where the supervision point that Stephen talks about is really important, that someone is using the right tool for the job, and an AI can present something that looks fantastic and sounds great, but you still need to understand what you're doing, and you still need to be able to to work with that. So you need to understand it to be able to work.
Quite. So, Steve, the role of precedent, I think, is a really interesting one here that Tim has just tapped into. So, from your perspective, is AI going to change the world of precedent for you and for your firm? What guidance are you going to give your organisation with this evolving technology?
It's a difficult question. I mean, at the minute, it hasn't made a big difference, and the most promising use cases currently for AI tend to be around reporting and summarization rather than the generation of new documents. And I think part of the issue with that is a more fundamental one, which is if you're working with a precedent, you can get to know that precedent quite well, and it's probably structured in a way that, even if it's not completely familiar precedent, is probably structured in a way that's immediately familiar to you. And so it's quite easy for the lawyer to understand the whole context of the precedent. Whereas if you were able to, if there was a system that could reliably generate a suite of contracts for, say, a commercial property development where there might be 4 or 5 quite large agreements, the difficulty would be that the lawyers wouldn't. At the minute, you can not read every page of a precedent because you know, if it's come from a reliable source, that probably the boilerplate provisions relating to notices are sensible. And if you move to an AI-generated one, I think you'd start to worry about that, and it would probably increase the mental load of the lawyer rather than decreasing it. And so I think there'll need to be, so it seems to me that sort of AI-generated precedent will emerge at some point, but it would need to be in a way that preserved that kind of familiarity for the lawyer. And what was coming out was, you'd know that some bits, it hadn't reinvented the notice provision. That would be the same as it always had been, but it fitted other bits to your circumstance. But I still think it would be easy to underestimate how hard it would then be for the lawyer to maintain familiarity with everything the document said, and then be able to negotiate it and amend it as normal without making some unexpected mistake because they didn't know the whole context. Whereas that's much easier to manage with a precedent that you know and understand. So personally, I feel like that bit is a bit further away.
Interesting.
And I think there's a client service point in that as well, in that the clients don't want a suite of lease contracts, for example, in their shopping centre where each lease is drafted differently. They want some consistency so they can navigate and use and manage their portfolio in the same way. So something that is wholly different every time you draft it would be actually a poor service, poor experience for the client, because the risk allocation is going to vary depending on what is drafted at that time. So I think precedents are still going to remain important aspect of the tool, but what I can see happening is that the AI tools will start to leverage precedents and maintain the drafting and the format and the structure, just with some nuance to it. But as you know, and that they would highlight where this has been nuanced, where this has changed, so that you can navigate those changes and identify, is this the right thing? And then you obviously still got to come back to the point that these things are negotiated, so you're still going to have the human negotiating and managing that part of the process.
So, well, let's look then at this idea of quality control, perhaps. I think that's quite an interesting area. So, Kat, as the innovation lead, right, is technology able to provide that level of quality control, or is that a very much a human-led piece?
I think it's a combination, isn't it? Like all things, and I think it very much depends on the type of area of law you're working in and the stage you are kind of in your career. Precedents have been handed down, haven't they, from trainee to trainee for generations, because they're tried and tested, and they give you that, starting point to be able to work through an area of law. There's certain technology that can, stop stupid errors creeping into documents and things. So, people just transposing stuff incorrectly between documents. But I think it's very much a kind of messaging around kind of think, write, AI and check. So don't lose that kind of cognitive capacity. And there's starting to be some quite interesting research at the moment about people who are given the same tasks either with an LLM or without it, and then what ultimately that looks like in terms of similarity of outcome. So they kind of tend to use the same kind of language. There's not a lot of there's not a wide variety of thought, obviously, from people who've used those kind of technology in terms of the answer, whereas people who haven't used them usually have a greater variety of language within the document and a greater kind of scope of reasoning within it. And I think it's very much that kind of law school 101, isn't it? It's think through what you're trying to do first, work out how you try to do it, write it, whether that be using precedents, whether that be using a bit of Gen AI, using any AI on top of it, and then checking it. So it's to try and keep those steps, because, as Tim said, the stuff is still coming back to you. If you don't understand why your draft is how it is, then anything that the other side is going to come back with, it's just going to massively confuse you. And I do think, it does very much depend on, I think, where you are in your career, how useful or otherwise some of this technology might be on a particular type of work.
Quite. Well, there's an interesting question related to this that Nicola has posted. So just to briefly paraphrase, Steve, what skills do you need to get your junior and your younger talent developing and building in this changing world for drafting? Nicola talks about how that there's a generational risk that things will evolve. Is that you, Steve? You're going to have to take that one.
I am sorry.
No worries. Tim, to you, what do you think about this generational risk? Steve will be joining us again in a second. He just had a very important personal call to take. Tim, did you catch that?
So I think what Nicola calls out is absolutely right. Yeah. So with AI tooling doing what it does, when I was a junior lawyer learning my trade, I would do legal research, I would attend meetings and take notes, I would manage conditions, precedent checklists, and do things. All these tasks that helped develop my understanding of my particular area of law are all now capable of being done by AI tools. So the tools which I learned my trade are being taken away, and then also people aren't in the office as much, and so you're learning by osmosis, or that quick question for the person across the roadway that might be accessible, that's not quite so easy to engineer. And so the tools by which I learned my trade are not as accessible as they were before. So I think, and then at the same time, as we've just been talking about, you still need that human to be able to spot where this AI's not got it right, or it's not the right nuance to this clause, and so on. So there's a challenge here that the tooling that we're using is more important, that we have that expertise to use these tools safely, and yet the development of that expertise is more difficult because of the tools. How do we resolve that? I think it's a challenge facing the industry as a whole, and we are going to have to take quite a human and thoughtful approach to how we train our people. It's going to need engagement. It's going to need time spent with juniors and making sure that they learn in some way. I think AI can have a role in that. We can use AI to develop experiential learning, simulation learning, things like that. That's certainly much more accessible than it was before, but we're going to need to invest the time in doing that, I think.
And just to follow up on that, we hear an awful lot about junior lawyers, but drafting is also done by non-lawyers. Is there anything there that might be different that we need to think about? Oh, Tim, you gone? Kat, what do you think? You were nodding there.
Yeah. So
Keep going, Kat, and we'll come to you, Tim, for follow up.
Yeah, I suppose if you haven't trained as a lawyer, you're probably limited in the type of documents that you're drafting. But I think those kind of same issues arise regardless of the actual kind of type of document. I mean, I was just thinking as Tim was speaking, you can get AI to generate you a court order, can't you? But what happens if you're at court and there's no Wi-Fi and the judge doesn't? The judge gives you 10 minutes to go and do it. All of those skills that you've actually, until you've had 10 minutes and here's you go out and do it, you've not really kind of thought about. So, lots of kind of practical things I think that we do need to do with junior lawyers as we're trying to progress them, because otherwise they'll start to deal with very complicated matters where they might not necessarily have the core legal knowledge and the ability to draft that perhaps we would have had in generations gone by.
Tim, anything to add to that?
No, I agree. I think it is. We need to take the same approach for lawyers drafting as any other draftsman. We need to take ownership and train and teach these people to know the tools that they're working with. And if that's words, we need to teach them how the words work.
Yeah, and are there lateral skills as well that we need to be considering? So we've talked about the drafting side, but there is, coming back to the Rembrandt example, right? There's the nuance, the refinement, that fine edge, the commercial knowledge. Are there other skills that become more important as perhaps that simple, basic drafting is becoming less important? What do you think, Kat?
Yeah, I mean, I think it's all the good old-fashioned kind of O-shaped lawyer stuff, isn't it? So open-minded, ownership, optimism, opportunistic, and original. So I was pleased when I remember all of them. And it's that, I suppose, it's trying to get people not so hung up on particular types of technology or particular software programs and that kind of thing, because we all know the kind of the tech we'll interact with will come and go. What we need is people who are I suppose resilient, able to deal with change, able to cope with us throwing multiple different pieces of tech at them, want to be involved in pilots, are happy to kind of be curious and questioning of things, so not to take everything at face value and go, oh, that's a computer's done it, it must be amazing. You still want people to kind of have that challenge, and asking why things are done in a certain way. So I mean, that's how we all learnt to draft, isn't it? The red pen by your supervisor and the kind of see me squiggle, which is why we've not done it this way. And it's I suppose it's almost the knowing why things aren't included is as relevant as why they are. So I think we still want trainees and junior lawyers coming through who are still okay asking those kind of questions and don't just think because it's the technology that it's going to kind of take all of that cognitive thought process away from them. And there will be times where the tech isn't available, so good old-fashioned drafting will be required.
Yeah, I agree. I think the other part that I would add to that, which comes into the O-shaped lawyer, is commercially grounded, because sometimes the answer isn't actually in your drafting. You could be battering back and forward on some negotiation and not getting anywhere. It's not drafted. It's you're not going to solve the problem by drafting. Maybe this needs a warranty and indemnity insurance, or maybe this needs a different approach. And that's not a drafting computer is not going to do that for you. You need to understand what the risk is at stake and how to address that risk. And that might be something outside of the contract, or it might be negotiating some other part of the contract to put a check and balance in place. And so I think that commercially wider view of it, rather than looking at drafting and negotiating a contract clause, it needs that wider view, I guess, that we need to teach our lawyers and that they need to learn. And that is not something that I can see AI taking over any time in the near future.
Well, so welcome back, Steve. Thanks for joining again. So the question I asked was, as those traditional drafting skills not necessarily fade but become less sharp, what are the skills that we need to make sure that lawyers as a whole, not just juniors, are increasing? Where do they need to put more effort to make sure that the work that's delivered still meets the standard required by clients? What are your thoughts there?
Well, two things. I think it sounds like you might have covered one, which is people really understanding the commercial context in which their clients are operating, or not just the commercial context. I mean, it might not be commercial, but whatever the context is, that's the really rich, interesting bit where lawyers can really add value. And anyone who's worked with an LLM at all will know that they can be extremely smart, but without context, they're really useless. So, and giving them the context is time consuming. To get good outputs, you need to give them lots of context, and that's difficult. But it does need somebody who really understands the context. So I think if lawyers are going to work more and more in partnership with AI, then understanding the context and being able to translate that into the AI would be much better. And I suppose the other bit is it's probably a good thing that some of the old skills will disappear because they can be made. Technology has the power to make drafting much safer and easier. And it could be a proofreader, a checker that you've used definitions properly. Are you using the passive voice and not? There's lots of ambiguity in draftings introduced through lots of things like use of the passive voice when they should have used the active voice. misuse of definitions, things defined twice the same way, or and if it operates as a checker through all of that, then I guess in one sense that would eliminate a skill that, you know, some lawyers are just really good proofreaders, but that shouldn't really be the core legal skill. It should be something else. And so technology seems to me to have the power to de-risk it and de-risk lots of drafting. And if that de-skills people, that's probably a good thing.
Okay, that's really interesting. So let's take that idea of de-risk. What I'm quite interested in is the client, right? How does the client feel knowing that their work has been partially or even completely AI generated, or has had an AI tool run across it to do validation? Is that something that puts clients at ease, or is that something that needs careful explanation? I don't know. Have any of you had experience trying to explain this to clients? Not yet.
I mean, we've had some conversations with clients around kind of using it and when it would be useful. I think the crucial bit, and it was a client who kind of said this, is that, you know, everybody can summarize suddenly documents in the same way, and that makes it quite legalese in terms of reporting back to a client. And if you've got a busy GC who is then used to kind of copying and pasting the relevant bits that they get from a lawyer, and maybe sending that round internally to people who aren't lawyers, then you've actually just made their job harder sometimes by giving them that LLM generated output, because they then have to turn that into language and I suppose syntax and that terminology that will be understood within their organisation, whereas the lawyer would have just routinely done that. So you've actually kind of pushed a job onto a client that they don't want to do, which I thought was quite an interesting take on it. I mean, I think clients' views on all of this kind of thing is very much like the discussions we had about innovation, you know, 5-10 years ago. I'm not sure clients massively care how their work is done, as long as it's at the price and the time frame that they want it. So I don't think, you know, they're not all going, oh, you're using Westlaw rather than printing off documents and that kind of thing, or, you know, you've gone to Lexis to do your research rather than going to a paper version of something. I think it's just the natural progression of that. I think they want the outcome, don't they? They're paying for that legal service, whatever that looks like. And I think the way that it's drafted and got to them, I think it's, as long as the price point is right and the time frame is right, I'm not sure they're at this stage massively concerned with how that's being done.
Interesting. Well, there's a point. Bruce has just made a point about value, and I think that's a really interesting one, about the value and the measurement of how do we recognize that what these tools are having. So I'm just interested. Maybe I'll go to Tim and Steve as well. I think your views would be quite interesting. Just reading Bruce's question: how do or should law firms gather management information to measure, in particular, the benefit or the detriment of introducing, in this case, we'll talk about legal drafting tools for the role of legal drafting, including AI or not? I don't know, Tim, I know you're a man who likes to track his numbers, right? What are your thoughts?
I think it's quite hard to be empirical about that. You can't associate. It's very difficult at the moment, or certainly with the data that we've got, to understand the return on investment on these tools. I think you need to take it partly anecdotally and partly based on usage and an assumption. So anecdotally, is this helping you do your job? Do you feel you're being more efficient in doing so, but retaining control and producing good quality output? And then, are people engaging with the tool and using it? Because if they're engaging, then they are seeing value in it. So I think at the moment, it's no more sophisticated in terms of measuring the return on investment than asking people and seeing how much it's being used. If they feel it's not adding value to them, they will not use it, because a habit is hard to change for lawyers. And so, you know, if we have effectively changed their habits by getting them to use a new tool, then that would suggest there's real value in the tool. But I don't think there's any kind of hard data that we can leverage to say, you know, this is saving us £28 a day.
Yeah. Okay. And Steve, what about you? Right? Do you think this is going to change? And let's talk midterm. Is this going to change how your legal services are priced and delivered?
I would think so, but it's very hard to predict at the moment. And part of the reason it's so hard to predict is that we've been on such a steep improvement curve with the capability of AI models. If that curve continues as it has over the last 3 years, the world will be very different in 3 more years from now. But it might not, and there's still some lag behind what the models are currently capable of and how easy they are to integrate into legal work. And so that makes it hard to predict what the overall income or impact will be. I'd be very sure it will have some impact on pricing. I think Kat's exactly right that clients don't really care that much how the work is done as long as it's done to a good quality. And so it probably will accelerate the trend towards value-based pricing for lots of work rather than...
Are your clients going to expect human oversight over that piece of work, or are they going to be quite comfortable with, if you say it's okay, it's okay? What do you think, Steve? Sorry, continuing your point there.
I think we're a long way from having no human oversight, and I think for anything that's important to clients, I think it would, at the minute, it would feel hugely risky not to have any human oversight. So I don't think that will change in the immediate term at all. I think at the same time, there would be an expectation from clients that we are using AI, because it would be hard to justify manual human input on things that AI can obviously do. And as people get more familiar with what AI can do, they'll be more used to expecting that people do it.
Totally. Tim, I think you had a point there.
I was just going to say, if the client were comfortable with no human oversight, then why engage the law firm except for their PI insurance? And that then becomes very transactional. That they're just, I'd like to buy your PI insurance, please, and that feels quite a different thing from a traditional lawyer-client relationship. So yeah, there is no value that the lawyer is offering if there is no human in the loop. So yeah, and I agree with Kat and Steve that the client shouldn't care really how we reach the answer, as long as we are owning it and taking that responsibility for our drafting, in the same way that we've used precedents and we used proofreading tools and we've used other things to improve the quality of our contracts. This is just the same, as long as the tools that we are using are used safely and are improving the quality of the contracts.
Interesting. Now, I'm very conscious of the time. We promised that this was going to be a short and sweet half-hour webinar, but I just want to sort of close with a couple of wrapping questions. Do you think, Kat, will future lawyers still need to, and let's talk a whole generation away, do you think they're still going to need to focus on building drafting expertise, or will AI take over? What do you think?
Yeah, I think they'll have to, because I think it's such a fundamental part of kind of understanding your case and the kind of the legal issues surrounding it. It's a bit like, isn't it, being taught to drive in an automatic car, and you can only drive an automatic car if you haven't got the kind of the manual training behind it. And I think, we've got to be really careful that we don't create generations of lawyers where they can do the stuff where the tech works, but where's the next random area of law that we're all going to be looking at, and suddenly there is no precedent or there's nothing, and people have lost that ability to be able to suddenly draft the documents and things that we need. So I think it is still a very useful skill. And I suppose universities like UCL have recently announced, haven't they, that half of their exams are going to go back to either written under exam conditions or oral exams, to remove what they say is this kind of content creation and AI slop, which is a very clear move from them that these kind of skills are important for lawyers.
Quite. No self-driving cars in Kat's world there.
That's 100%.
Steve, right, so
well, I was going to say,
go on, Tim.
I was going to say I would dissent. I think that we will lose our drafting experience, our drafting expertise, and I think AI will start taking more and more of a role. And I think that is a risk for the reasons you've outlined, Kat. But I see it taking more and more of a role in the near future.
Well, so let me put the next question to you then, Tim. Will losing those traditional drafting skills weaken legal advocacy and legal reasoning?
Yes. I don't think I think that there's no sugarcoating that. Yes, it will. I think that the two kind of go hand in hand, and we need to understand the real depth of the law to be able to draft effectively. We need to know what the impact of adjusting this clause will mean for the rest of the contract, the rest of the risk allocation in that. And I think that that legal reasoning, if we're not using it as a muscle that we're not using, then yeah, we will get poorer at it. And that's coming back to my earlier point. We're going to need to be really thoughtful about how we train lawyers to understand the law.
Quite. Well, let me put the final question to you then, Steve. You'll get the headline question, right? Is legal drafting becoming a commodity, or is it still and will always remain an art form? Can you hear me? Maybe he can't hear me. Well, in that case, let's wrap that up there. Thank you very much to everyone who submitted so many questions. I'm afraid I just couldn't stay on top of them with my own thoughts there. Thank you very much to our wonderful panel for contributing their thoughts. It's very much appreciated. Unfortunately, it does look like we've lost Steve there a bit, but thank you very much indeed, and have a good rest of the day.